Well, hello there and welcome again to the Employment Law Show. Good to have you along. Hope you can stick around for the entire 30 minutes. My name, just hosting, John Scholes. With me as well, Lior Samfiru. Reach out to Lior anytime, as we've been telling you for years. Make that the first phone call. 1-855-821-5900, help@employmentlawyer.ca. And I'll give you a website right now. We're going to talk about it and use it later in the show, but you should always know about it, called pocketemploymentlawyer.ca. It'll cover a lot of what we talk about on this show every week, plus it'll give you access freely and anonymously to what we call the severance calculator. That used to be a standalone website. Now it's all rolled in for convenience, and it does exactly what it says in the title. It takes about 25-30 seconds. You can do it anytime on your smartphone, tablet, on your desktop at home, and figure out how much severance you would be owed really accurately if it came down to the time that you lost your job. Again, pocketemploymentlawyer.ca. We'll take it out for a spin, as we say, a little later on in the show, I'm sure. Plus, our main topic a little later on in the show this time is 5 things employees should know when starting a new job. Most of these will surprise you. It's not what you're thinking, so we'll get to that in the near future. Lior, that's some emails as well, possibly some phone calls from our radio show. So there we go. Week that was is how we start. Pal, what do you got?
Hey, John. Great to be here, of course, to talk about employment law. There's no lack of topics. There's no lack of things to discuss. There's no lack of information to convey to our good viewers. If you have a job, whether you've been working for a while, maybe you're looking to get into a job, maybe you lost your job, you have rights. There's rights that apply to you. You need to know those rights. No one should work without knowing and understanding your rights. You don't drive a car without knowing what the law is about, speeding and about what you can and cannot do at a stoplight. Well, you shouldn't work without knowing your rights as well. It's an invitation for bad things to happen. Well, on this show, we do what maybe others don't, which is tell you what your rights are, inform you and educate you, give you that knowledge that you need to know to make sure you're not being taken advantage of. You don't walk away from your rights. And those things have to do with losing your job or being mistreated in your job, being discriminated against, having your job changed. All those things are important things you need to know about, because if it hasn't happened, it may happen in the future. Not being pessimistic, just realistic. I speak with people every day that had worked for a while and they assumed that things are going to continue being great, and something happened, it changed. Maybe a new boss came in, maybe a company was sold. All of a sudden, things are not the same way they used to. They need to understand their rights. Same with you at home. You need to have that knowledge. And John, case of the day, let me tell you about a situation that came across my desk. I spoke with a gentleman that never had a problem, worked for 5 years with the same company. Well, recently he moved. He moved further away from the company and had to take an additional bus to get to work. Well, he wasn't very good with that, managing that new schedule, and a few times he was late to work. He just didn't give himself enough time to get to work, and traffic in certain areas, as you know, not the best thing, and it can impact you. And his employer, obviously, and for good reasons, was not happy with him. Well, after this happened 3 or 4 times, he was called into a meeting and said, yeah, we talked to you about this. That's not acceptable. That's your problem, Mr. Employee. We're letting you go for cause. We're going to pay you till your last day of work and give you outstanding vacation pay, but that's it, nothing else. Bye-bye, off you go. So this case is a great example of just how difficult it is for an employer to establish cause, just how difficult it is for an employer to let someone go without paying them their full severance. Let's be clear. This employee was in the wrong. This employee, it was their fault that they didn't come to work on time. It was their job to manage the schedule and leave home early enough to get to work on time. No question. I'm not suggesting that the employee didn't do anything wrong, but that's not the question. The question is not, did the employee do something wrong? The question is that bad enough to be cause? Is it bad enough to deprive them of their severance? The answer is no, it's not. It is very, very difficult to be let go for cause. What the company has to show is that whatever you did was so bad that it's just not conceivable to employ you. Now, in this case, he never got any formal warnings. They talked to him, but never anything formal. He was never told, hey, if this happens again, you're gone. He was never led to understand just how serious it was. The company didn't do its job to build up the case to justify a termination for cause. And because of that, he's now been wrongfully dismissed. He's owed severance probably north of 6 months' pay. Again, he did something wrong. In fact, he did a few things wrong. He was late several times when he shouldn't have. But that's not enough for cause. And I wanted to remind our good viewers out there that if you you've done something wrong. Maybe your performance was lacking. Maybe you made a mistake. Maybe you even said something you shouldn't have said. None of those are good things, but that doesn't mean you can be deprived of your severance. If you are let go, unless you did something terrible, you are owed your full severance, and you have to give me a call.
Okay, so from the employer's standpoint, if they want to do a termination and not pay any severance, would they have to have said, as you just said, build up a case against them? You don't do it again, we're going to give you some warning, we're going to give you another chance, and slowly build that up, right?
Yes, the employee has to have knowledge, number one, how serious it is, and number two, what's going to happen if the conduct continues. The employer wants to be able to show we give that employee every chance to change their way. So what more can we do? We can give another warning. What's the point? We've tried that already. This employer didn't do that. They didn't provide any formal warnings. They certainly never told the employee, hey, if you don't come back or if you don't come to work on time as expected, we will let you go for cause. They didn't do any of that. So the net effect of that is that employee was not properly fired for cause and owed full severance.
Now, they could let him go like that, the difference being they would have had to pay him full severance in this case, correct?
They could have let him go for this reason or frankly any reason as long as proper severance was paid, about 6 months pay. But if they want to try to avoid that, they have to do the work on the back end to make that happen.
As I mentioned off the top, phone calls, we like to get them on the show. How do you get a phone call on the air? Well, you call into our radio show, which we've been doing pretty much across the country for about 11, 12 years now. So you can find one on the website, employmentlawyer.ca, a station that is that carries our show. And most of them are either half hour and hour long, so all kinds of opportunity to ask your questions may appear in this show. First of 3 phone calls for the show today. Lior is coming up right now. Listen up.
My husband got terminated yesterday. They called him into the office. This is a company that they called him 3 years ago and said, please come and work for us. And he just got terminated. He was middle manager making about $150,000 a year, and they offered him 3 weeks. Is this normal?
And how old is your husband?
55.
And he was recruited away from another company?
Yes.
I like that recruitment piece is key, right, in this story.
It is extremely important because if you're a short service employee, but you were recruited from another job, then you're let go. Maybe things didn't work out the way everyone had hoped. You're potentially owed enhanced severance that recognizes your time with the previous company. So if you work for a company for 6 months, but you're recruited from a company where you were working for 30 years, then you're let go. You now may be a 30-year plus employee and you could be owed 2 years severance, even though you only work for the company, the new company, for 6 months. Now, this person, we don't have all the information. We know he's worked for the new company for 3 years, but he was previously recruited from another company. Don't know right now how long he worked for that other company, but he may well be owed enhanced severance that recognizes that time with the previous company. But even if we put that to the side and just focus on the 3 years that we know he worked for the new company, 3 weeks is what they said they're going to pay him. Is that enough? Of course, it's not even close to being enough. Let's go and use our severance calculator for the first time today. We're going to go to pocketemploymentlawyer.ca, use that calculator, and let's see what this gives us. So this person is 55 in a middle management position, been there for 3 years, was offered or paid 3 weeks. We see he's owed 6 months pay. 6 months, that's, I don't know, that's much more than 3 weeks, put it that way. So because of that, this person was wrongfully dismissed. And this is before we even think or talk about the fact that he was recruited from another job. That's how easy and how effective that severance calculator is. So check it out yourself at pocketemploymentlawyer.ca.
So, Leo, the first point of clarification on this one is he didn't come knocking on their door, they knocked on his door. That's different.
For that recruitment aspect to increase your severance, yes, it really has to do with, did they come to you, did they convince you to leave, or did you apply there? Were you trying to get hired by the new company? If you weren't trying to get hired, you were content to where you were, but they came, convince you to leave, whether it's directly or through a headhunter, and they said, you're our person, we want you, and that's why you left, that means that in the first few years of service, if you're let go, you're owed that enhanced severance.
Yeah, I think you just answered it, but how long is that new employer susceptible to that previous experience? A few months, few years? Does it depend on how long the service was before?
It does depend on how long the service was before. The longer the service before, the more it's going to stay with you. But generally speaking, it's in the first 4 to 5 years with the new company that you may be owed that enhanced severance from the previous company. So certainly, always, doesn't matter who you are and what happened, it's always vital that we speak if you lose your job. It becomes that much more vital if you were recruited by your current company to leave your previous company.
And that is phone call number one. As I mentioned, threes in this show. Let's get to phone call number two right now.
But what happens if you experience something during your probation time by an individual while you're at work, and then you're dismissed during your probation time, and that employer doesn't report the harassment or take you through the investigation periods or to document anything, so that by the time they do that, your probation time would expire, and they just opt to not investigate and fire you offhand?
That doesn't surprise me because you're almost like not really an employee. You're still on probation. You're not fully ensconced in the place. Well, off you go. You know what I mean?
Except the only problem with that is completely illegal.
Exactly. Completely
illegal.
Yeah.
Your employer has to always foster a healthy work environment. They have to eradicate harassment from the workplace. Whether you're on probation on your first day or you've been there for 50 years, doesn't matter. So if you're already on probation, you're telling your employer you're dealing with workplace harassment, they have to investigate. They have to take it seriously. They have to rectify that. And guess what they can't do? They can't let you go because of it. And they can't hide behind the fact you're on probation. Oh, we just let you go during probation. No, none of that is legal. It could be a violation of several statutes. By the way, you may not even have been on probation because probation is not automatic. So yes, an employer cannot use probation or the fact you're on probation as an excuse not to properly deal with workplace harassment.
We'll get to phone call number three after a short break, and then we'll get into our main topic as well. 5 things employees should know when starting a new job. This is huge information this week, so stick around for that and that third phone call on the other side of the break right here on the Employment Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes and Lior Samfiru. Reach out anytime you would like. You're encouraged to do so before you make that first move. If there's something bothering you or harassment or any other situation at work, just make the phone call. Won't cost a dime to pick up a phone. 1-855-821-5900. Help at employmentlawyer.ca. And employmentlawyer.ca, the website. You want to find a radio station in your location. You can tune into our show weekly on that and phone in anytime. Ask your questions during the duration of the show. Okay, phone call number 3, Lior, from one of our radio shows is coming up right now.
I stated at the beginning of my employment, every Wednesday, due to custody reasons, I would start at the regular time, but I would have to end at a certain time in order to pick up my kids. They sent me an email after about a year saying this is no longer acceptable. If you're going to continue to do that, then are going to pay you at a reduced rate of $20 an hour instead of $25 an hour.
Yeah, okay.
So let's start with the basics here, and that is that an employer has to accommodate family responsibilities, okay? So we call this accommodation based on family status. What that means really is that if you have certain childcare obligations, and the only way you can meet those obligations is through your employer's support, their accommodation, well, that employer has to provide that accommodation. They can't say, we don't want to. Now, in this case, we know your employer is able to provide that accommodation because they've been doing it for a year. So they can't say all of a sudden something has happened and we just can't accommodate. But here's the thing. If your employer accommodates you, you're still expected to continue to look for ways where you won't need that accommodation anymore.
It's up to you first.
It's up to you first. Right. So can you find someone else? Can you make arrangements with a daycare or a nanny or a relative, etc.? Now, in some cases, you've tried, you've looked, and it's just not possible, in which case your employer still has to accommodate. If you can make other arrangements, you should. So in this case, here's what I would tell this person. If you can find other arrangements, you actually should do that. If you cannot, Tell your employer, send an email saying, hey, employer, I've tried to find other arrangements. Here's what I've done. Here's what I've done to find those arrangements, where I've looked and what I've done to make it happen, and I couldn't. So I'm asking you to continue accommodating me. If they don't, if they say, we don't care, that's your problem, that's a you thing, not an us thing, that's a human rights violation, and we can deal with that. We can help you. I can certainly get the company off your back and get them to accommodate. But I do want the employees that are asking for this family accommodation to make efforts to try to deal with that without their employer's help first.
How about this little cut in pay, the $5 drop in pay?
Well, if your employer no longer is under an obligation to accommodate you because you didn't do what you're supposed to, they can say, well, we'll only accommodate you if you take a pay cut. Otherwise, you can go back to your usual job. But this all stems from the fact that if your employer is obligated to accommodate, they shouldn't be cutting your pay. So when it comes to family status accommodation, make your own efforts first. If you cannot find other childcare arrangements, tell your employer in writing, impose that duty on them at that point.
Again, there you go. That's why you join us weekly on our radio shows to get some information, make that phone call and follow up as well. I want to get to the main topic now as we continue on this week. 5 things employees should know when starting a new job. Listen to these. Write them down if you have to. Number 1, you don't need to have an employment contract, but if asked to sign one, have it reviewed by an employment lawyer first. Big time.
So first of all, you actually don't need a written employment agreement or a contract of employment when you start another job. You don't want an employment agreement when you start another job. You'd rather go and shake someone's hand and say, yes, you're starting Monday. That is good enough. Or even better, just an email saying, yeah, you're starting Monday, here's your job and here's your pay. That's fantastic. Because oftentimes what an employment agreement does is it takes away rights that you would have. You have all these rights that the law gives you automatically, but an employment agreement can often take away those rights. It could cost you money by way of future severance. It could give the company rights that it didn't otherwise have. So no, you don't want an employment agreement. But let's say you do. You're provided with one. I'm here to tell you, you want to look beyond just what your salary is or how many weeks vacation. Most people look at those things. As long as salary and vacation are fine, yeah, it's good enough, let's sign. No, there's other things you want to look for. Is there something that limits your future severance? That could cost you tens of thousands of dollars. Is there a non-competition obligation? That could be hugely problematic. Does the contract give the company the right to change your pay, change your hours, change your work location? Again, hugely problematic. Imagine, John, a situation where you sign an employment agreement where it says, we can let you go at any time, pay you almost nothing. Yeah. Oh, and by the way, if that happens, you can't work in the industry for 2 years. You understand now why you can't look at just your salary. So that employment agreement, very important document, have me review it before you sign it.
Which is counterintuitive because most people want this document, not this one, right? They're scared.
They feel protected by it. Well, I have this employment agreement that's very thick and a lot of words, so clearly that must protect me. No, it protects your employer. So for employers, if I'm going to stand over there and talk to employers, I would say, sure. For an employer, you want that thick, extensive employment agreement. For an employee, less is more when it comes to employment agreements.
All right, next thing you know about starting a new job. Point number 2, if you are put on a performance improvement plan, protest that decision, but in writing.
That's right. So if you're on a performance improvement plan, your employer puts you on one and you don't agree with it, you don't think it's fair or legitimate or accurate, protest it, respond, say so in writing. Send an email. You don't have to be a long email. It shouldn't be aggressive or disrespectful. But send an email telling your employer why you don't agree with it and what's missing in it. By doing that, you're protecting your job. You're making it very difficult for the company to let you go for cause. A performance improvement plan is often a step used by the company towards a termination for cause. But if you respond to it properly, you essentially make that impossible.
Starting a new job, 5 things you need to know. Number 3 today is this: you do not have to accept major and unwanted changes to your job.
So when you accept the job, the terms of your employment are set at that time. Your position, your salary, your hours of work. It's whatever you've accepted. So what happens if the company says, yeah, you know how we hired you for this job and to do these hours? We're changing that. We're demoting you. We're changing your hours. Maybe we're changing your pay. Well, not so fast. That's not the deal. That's a breach of the terms of employment. So if your employer does that, you may be able to consider that to be a constructive dismissal and get your full severance. So you can't physically restrain your employer from changing your job or hours, but what you can do is not accept it. Consider that a constructive dismissal. So generally speaking, the terms you signed up for are the terms you should have throughout your employment.
Number 4, Lior, is this: you can be let go from your job for almost any reason, but you must receive severance pay.
So when you accept a new job, you often don't think about what happens if I lose my job. But you have to think about that. You have to understand that, yes, there's really no such thing as job security. The fact that you're doing a good job and you're a good employee does not mean you're going to keep your job. It should mean that, but it doesn't mean that. You can be let go for most reasons, even if you've done nothing wrong. But, as John said, you have to get your full severance. That could be as much as 2 years' pay, and it's a lot of severance even if you're a short service employee. So you start a new job, things didn't work out, maybe you lost your job after a few months. Even in that scenario, your severance is calculated in months, not days, not weeks, in months. So keep that in mind, and always, 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 if you lose your job, call me.
Last thing you need to know for the topics of 5 things employees should know when starting a new job. Big one, though: if you're recruited away from another company, those years of service should be reflected in that severance package.
So we talked about that earlier on the show, about being recruited from another job. But this is also where that employment agreement that we touched on becomes very important. If you haven't applied for a job, you weren't necessarily looking to leave your old job, the company that you're going to be working for, they came knocking on your door. They came to you and said, you're the one that we want working for us. And then they're going to put an employment agreement in front of you that limits your entitlements? No, don't let that happen. You want to make sure that you don't sign up for a probationary period at that point. You don't want to sign up for something that limits future severance, because you actually may be owed enhanced severance because of the fact that they recruited you from another job. So that employment agreement is always key. I think I've made that point earlier. It's that much more important if you're recruited from another job. And certainly, always, 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 if you're recruited from another job, even if it happened a few years ago, you lose the new job, you call me right away.
And that is the main topic for this week's show. Again, any of these talking points that we discussed here can be found, a lot of them, at pocketemploymentlawyer.ca, or just reach out to Lior and make that phone call and ask Lior and his staff. We'll take a short break and get to more of your questions on the other side, right here on the Employment Law Show. Stick with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back, Employment Law Show. Thank you so much for sticking around, including the phone calls, the radio shows, the TV shows. Lior also does a lot of live streaming as well. He's actually got the time. Don't know where he finds it. LinkedIn, Facebook, YouTube, at ST Lawyers, if you want to join that particular show anytime. Here's a question for this week. Lior says, I am currently employed as a full-time receptionist for a local group home. I was hired 5 years ago for the position with a regular Monday to Friday, 8 a.m. to 4 p.m. shift. My employer is now advising me that they will be changing my hours to include weekend shifts. Do I have any leverage, or can I resign due to this change and still get compensation? I'm 48.
So it's obviously something the employer cannot do. And you know, having to work weekends when you're not is a big deal. Any person that's been through that will tell you. So your employer doesn't have a right to make that change. So, you know, I said before the break that generally speaking, the terms of your employment are crystallized when you accept the job. Well, certainly they're also crystallized based on what you've been doing over the years. So if you've always worked weekdays and now that's going to change, that's going to be nights or it's going to be weekends, that's not allowed. So what does that mean? That means you may be able to treat that as a termination, as a constructive dismissal. So if she's asking, can I resign? Well, you can always resign. You don't have to have a reason to resign. But the key here is that if you resign, you may actually be owed your full severance, even though you're the one choosing to extract yourself from that workplace, to leave that job. The law may consider that to be a termination of your employment. So what do you do here? Before you make that decision, of course, you want to know how much you're owed. Would I get 1 month severance, 2 year severance? So let's go and use our tool once again, the severance calculator. You can find that at pocketemploymentlawyer.ca. And let's see how much this person would be getting, even though she'd be the one choosing to leave. So she's in a clerical role, been there for 5 years. She's in her 40s. Company is not going to offer anything because from their perspective, they're going to have an employee that resigned. But because this is a termination, constructive dismissal, we see right at the bottom there, she's going to be owed 6 months' pay. 6 months' pay. So constructive dismissal, regular dismissal, the severance calculator works just as well. You can find out for yourself how much you're owed, how much you could be owed. Just go to pocketemploymentlawyer.ca.
Another place to go. We give you all kinds of options here on the show. Terminationquestions.com. Lior, here's the question from that website for this week. Can my employer say I resigned even if I did not do so? After calling in sick for a week and providing a doctor's note for medical leave, a supervisor called to inform me that this was considered job abandonment and refused to answer any of my questions. Nice.
John, why do employers do that? I mean, seriously, do I have to be here and say that's not allowed? Isn't that obvious? Nonsense, of course. You can be off as long as you need to be off, so long as you have your doctor's support. There's no limit of a week, a month, a year. You can be off as long as you need to. It's not a job abandonment. It's not a resignation. It doesn't give the company the right to let you go. So what happens in this situation? Well, the first thing I would want this person to do is to email their employer right away, say, no, I'm not abandoning my job. I will be coming back to work as soon as my doctor says I'm clear, and I'll provide you with the note as soon as that happens. If the company still says, too bad, we don't care, well, that's a termination, not a resignation. They're owed severance. Potentially, that's a human rights violation as well. It could be owed additional damages. So wrong, illegal. Get that doctor's note. If your employer still doesn't care, you call me. I'll make them care.
All right, let's make Lior sweat here for the last couple minutes of the show with employment rights rapid fire coming up right now. Okay, Lior, first one. Can somebody be permanently replaced if they go on mat leave?
No. Now, the key word here is permanently. You can be replaced while you're on leave because the company may need the job to be done, but you cannot be permanently replaced. If you're on parental leave, a mother or a father, you have to be taken back to the same job, same pay, same everything, and the company can't just say that they've replaced you. That's illegal.
Number two, can employees refuse to work an overtime shift?
Generally speaking, the answer is yes. Now, the exception to that is a situation where you sign an employment agreement where in that agreement you say you agree to work overtime if asked. If you didn't sign something like that, you can refuse overtime. You can't be punished for it, so keep that in mind.
Number three in the rapid fire is this, Lior. If you are denied long-term disability benefits by your insurance company, does your employer have the right to fire you?
Absolutely not. What you're owed from your disability insurer is different than what your employer must do. As long as you have a doctor's note, I don't care what the insurance company says, you can be off work, you cannot be fired, you cannot be considered to have resigned. So just get that doctor's note. And if your insurance company cuts you off before they should, call me. We have a whole team dealing just with that.
Number four coming at you. Should employees resign/retire if pressured to do so?
Absolutely not. No, retirement is something that you do when you're ready and if you're ready. Same with the resignation. You do it on your own. If you're forced to resign, that's a termination. If you're forced to retire, that could be a human rights violation. You don't have such thing as mandatory retirement anymore, and employers should never, ever put any pressure on you to resign.
Rapid fire number five. Are employees obligated to inform employees if they are being monitored? Wow.
So generally speaking, no, if you're being monitored in a public area of the workplace. Now, if you're being monitored in your own private office, yes, they would have to tell you. Otherwise, that would be a breach of privacy. So the location matters.
Number six, can an employee be let go for cause for lying to their employee?
No. Generally speaking, one incident is not going to be enough. Now, if you made a major lie that caused your employer damages, potentially you can be let go for cause. But in most cases, one incident of misconduct is not going to be cause.
Last one, let's get it in. Do employers have to provide notice before letting an employee go?
Well, they can provide notice or severance in lieu of that notice. Most employers don't provide notice, but they have to pay full severance.
Got it all done. And we're out of time for this week. Reach out. Don't forget to do that anytime you have questions after the show. 1-855-821-5900. help@employmentlawyer.ca. And that website, we told you, use it, pocketemploymentlawyer.ca. Thank you so much for joining us. We'll catch you next week right here on the Employment Law Show.